Hello, I'm Stephen Gold, and I've had a haircut to help me think straight about the legal developments to bring your way. And there's plenty of law and how to win or lose well in my book, The Return of Breaking Law.
Oh, it's Tom messing about.
These days, there's an ombudsman to complain against virtually everyone, except clapped out former judges, that is. The Legal Ombudsman, he deals with complaints against legal professionals, that's barristers, solicitors, accountants who do legal work, licensed conveyancers, and a few others. It's a free service. If you're upheld, you'll get an apology and compensation. It's an alternative to court proceedings. You can't do both. The trouble is, the Legal Ombudsman takes too long. The solution? Cut down on the time within which you've got to make a complaint to the Ombudsman. And that's what he's done. For complaints made on or after the 1st of April 2023, you've got to get your complaint in within 1 year of the cock-up you're relying on. If you couldn't have realised there'd been a cock-up within that period, then you've got 1 year from when you should have realised. Before going to the Ombudsman, you should and you must exhaust the legal professional's internal complaints procedure. The Legal Ombudsman upholds something like 1/2 of the complaints made to him. Are you claiming compensation for a personal injury which you've suffered in an accident? Well, quite apart from compensation for the injury itself, you're entitled to claim compensation for special losses like loss of earnings, cost of repairs to your car, damage to your motorcycle helmet, and you should go after interest on those special losses. These days, that interest is often, more often than not, awarded to you in line with what is called the Court Funds Office Special Account Rate. You get the whole of a rate or a half of it for continuing losses. And that rate's been progressively increasing. In June of 2022, it was a paltry 0.1%. It's now 4% as a result of an increase which was announced and was effective as from the 13th of February 2023. But as a result of the increase in the Bank of England base rate, which was announced on the 23rd of March to a tune of 0.25, 0.25%, it's likely that the special account rate of a Court Funds Office will go up again. So if you're dealing with a claim yourself, make sure that you claim that interest for the various periods at the various rates concerned. And if you've got a solicitor acting for you on the claim, make sure that they do that as well. Otherwise, you might have a compensation claim to the Legal Ombudsman. If you reckon your boss is about to sack you, then plead with them, please hold on until on or after the 6th of April 2023. The reason, don't tell them this, is that the amount of compensation you can be awarded through an employment tribunal for unfair dismissal, which takes place on or after the 6th of April, is going up. And there are increases in other awards for sins by employers on or after the 6th of April. For example, the amount of what's called the notion of 1 week's pay, and that's used, amongst other things, for the purposes of calculation of redundancy payments, that's increasing from £571 to £643. And the compensatory award for unfair dismissal, the limit, is rising from £93,878 to £105,707. If you haven't got too much capital or income and you're about to bring legal proceedings or take a step in legal proceedings which is going to attract a fee, and almost everything does, then you may qualify for the Help with Fees scheme, sometimes called fee remission. You can apply online. If you get remission, then the fee will be waived or part of it will be waived. Well, the big news is that the government is consulting on changing the law to make it fairer insofar as this scheme is concerned and easier to financially qualify. My guess is that the proposals will be implemented and come into force before the end of the year. So if you're out of the scheme at the moment, then, well, you could consider holding off until the changes come into force. But do be careful, because there are very strict time limits which have to be adhered to for starting legal cases. For example, to bring a claim for damages for personal injury, you must bring that claim within 3 years, normally 3 years from the date of the accident. Of course, the alternative and secret course you could take if you're out of scope because you've got too much capital is to book an afternoon champagne tea at the Ritz Hotel and then apply for help with fees once the pastries have gone down the hatch. You will have heard about the women's rugby match case, the Sirens versus Bracknell Rugby Football Club. The 28-year-old mother of two was playing her first competitive game when she was tackled by an opposing player, and as a result she sustained injury to her spine, which rendered her paraplegic, and she'd be wheelchair dependent for the rest of her life. She sued the tackler for damages for negligence. Now, sustaining injuries in games of rugby and in other contact sports such as football are pretty common, but the law treats the injured player as having consented to run the risks of the sport, so they can't claim for damages if they are injured, unless, that is, there has been a negligent foul. And that, Howard v. High Court judge in this case, is precisely what there had been. The test was, had the tackler used the degree of care which was appropriate in all the circumstances. It wasn't necessary for the injured player to prove that the tackler had been reckless or been responsible for a high degree of carelessness. You still playing this weekend? Capital gains tax. Ooh. Where spouses or civil partners separate and the family home or any other property is transferred from one to the other, there could be a potential capital gains tax by Revenue and Customs, subject to any other reliefs which may be available, if the transfer has taken place outside the tax year of separation. Well, that position is going to change under the Spring Finance Bill 2023 in relation to transfers on or after the 6th of April 2023. If the transfer takes place within 3 years of the tax year of separation, then there will be a deferment of any capital gains tax payable, subject to other reliefs, until the disposal by the person who took on the property. And if the transfer on or after 6th of April 2023 is pursuant to a court order, there will be no 3-year limitation of time. There will also be other changes fairer to the taxpayer, where one party preserves an interest in the property, and also where one party is entitled to a share of the proceeds of sale when the property is ultimately sold. It's a bit confusing. If you are about to transfer or be involved in a transfer of property on separation, you could save money. Take advice from your solicitor or accountant about timing. Very important.